One of the common views today is that older principles of natural law are largely irrelevant to legal discourse. This is a radical shift from the views of law that were taken for thousands of years, in which natural law was thought to be the foundation. What one means by natural law is that there are certain kinds of features of the world which are so common and so powerful that any legal system that tries to put things together in ignorance of those things will always fail. Natural law has been defined from the beginning of time as involving the following three principles. One is there's a certain kind of natural reason, i.e. the kinds of rules that allow human beings to flourish, and that you try to understand this by both observation and deduction. The second has to do with customs that are observed across different cultures. And the theory is that if everybody is doing more or less the same thing, it has certain kinds of survival value. And the third has to do with the survival of a particular kind of practices within a given culture. And it's the same kind of argument. Long-term practices only survive if they work for the benefit of the people who have them. One of the ways that you understand the power of natural law is the observation of commonality across legal systems. So every legal system will have to have rules developed to deal with marriage, but the formalities associated with marriage will differ. Every legal system has rules that would make sure that you can certify who owns things, but the rules of first possession will nonetheless remain constant. Every legal system will have to have rules that allow for the transfer of property by sale, but the formalities, whether they're in writing or whether or not there's some other special kind of oath that must be stated, may well differ. And so what you see throughout legal systems is that the underlying social relationships having to do with cooperation, marriage, sales, hire, and so forth are all the same across time and across places. And it's that universality which leads to the notion of natural law. In dealing with simple rules and with natural law, reference is often made to the state of nature. And essentially, this is both a historical and an analytical concept. What it means basically historically is that the world begins long before the state is formed. And so when people have to figure out what their relationships are with one another, they must do so under circumstances where there's no central power to tell them what is going on. And what natural law says is, in this particular state of the world, the following rights and duties will essentially improve the welfare of the individuals in question. And that immediately gets you back to the universals that we talked about: individual autonomy, the acquisition of property, the need for voluntary transactions, and the need to constrain the use of threat of force.